Welcome everyone to this month's webinar that is featuring myself, Rory O'Hara, founder and senior managing partner at Ausperity Private Wealth, and one of our rockstar advisors and certified financial planners, Sam McKee, as we will be discussing the estate planning process, going through a little bit of why to create an estate plan, how to go about doing so, and then what should be included in your estate plan. So thanks everyone for joining. Sam, you want to just do a quick reminder for how we would be taking questions and how that's going to work?
Yeah, absolutely. We're excited to get started today. If anybody has a question, I realize there is a raise hand feature, but we actually ask that you use the Q&A box where you can type your questions in. We'll see them appear on the screen and then we can answer them as we go through. So feel free to pop them in the chat as we present.
Awesome. So big thanks to Sam who built out the deck here. We will be sending this as a follow-up to everyone who attended. And there's a reason we're having this webinar in January with New Year's resolutions, etc. What we find at Ausperity Private Wealth is that estate planning and creating a simple will or creating your own estate plan is the single most procrastinated financial planning item. So we're bringing it to you in the start of the new year as hopefully a reminder that if you have an estate plan, dust it off, review it, look to see if there's any edits, check on your beneficiaries. And if you do not have an estate plan or a will, this is the call to action from us. So Sam, I'll let you take over the reins as we begin the discussion today. But this is for those that also, as we can see on the screen here, have said, I'll get around to it, or I don't have anything to plan for. Well, let's answer those questions after we go through the discussion today.
Perfect. Yeah, I mean, most of you who I've interacted with, one of our top 5 action items every year seems to be dusting off the estate plan, as Rory mentioned, or just creating one in general. So we'll talk through how you can do that, why, when, who you can label as your executors, trustees, and whatnot throughout this presentation. So just to jump right in, as I just mentioned, we're going to go through a few of the key questions that we get a lot of the time on estate planning. So who needs an estate plan? What should my plan include? When should I create and update the plan? How do I do it and why? It's going to be pretty comprehensive, but again, feel free to submit any questions throughout the presentation through the Q&A chat feature, and one of us will be able to kind of flag it and go through it. And we find that the best way to have these webinars is when they're more interactive and we do have questions, because it just makes it more interesting for everyone involved. So let's just jump to the next slide. So who needs an estate plan? I think we've answered that question a few times now. Pretty much everyone, even if you think that you don't have anything to plan for, creating an estate plan, which would be like your wills, powers of attorney, potentially a trust. It allows you to dictate, who's going to receive your assets and when you pass away, what they'll receive, when they'll receive it. This especially comes into play if you have minor children. You don't want to give a 10-year-old $1 million, and then how they'll receive it, whether it's, liquid assets, maybe it's property, other things like that. If you do not have an estate plan, one of the biggest things that I think we see in our industry is people want to keep things private. There's always the millionaire next door. We talk about that a lot in our meetings, and it's like most of our clients don't realize just how wealthy they are. I know Rory's favorite line is, you might not walk around thinking that you're a millionaire, but you are, and you deserve to have that privacy. So if you don't create your estate plan and your estate goes through probate, which is when the court kind of decides where things are going to fall, you do risk losing that privacy. I think a great example is, Prince. Everyone knows Prince, the color purple.
Yeah.
When he died, he didn't have an estate plan. So everything is public information, which can lead to more family drama, people knowing things that you probably wouldn't want them to know. And then you're also losing the opportunity to save taxes and make sure that your wishes are followed, especially, again, if you have minor children. Do you really want a judge choosing who should be the guardian of them? God forbid something were to happen to their parents. I don't think so.
Sam, those are all great points. And I'll just kind of follow up on that last point there, that, you're working so hard to create this wealth, and, family is what many of you care the most about. you want to have the control. You want the control of making the decision for who receives these assets that you've worked so hard for, or maybe even taking a step further and determining how they have access or how they receive those assets. So again, everyone should have an estate plan. The level and the complexity is going to be specific to you and your family, but if you don't have one, I think the argument can be made that everybody that is working and creating wealth should have an estate plan, and put the control back in your hands. Don't leave it up to the state in a default.
Perfect. So a few of the common estate planning goals that we see are, preserving and enhancing your wealth, achieving more tax efficiency. We'll go through the federal tax limits. We've worked through gifting strategies with a lot of you. So that's a big one. Enhancing creditor protection. So that's, if you were to pass away, you don't want, if your kids are having creditors chasing them, you want to protect the funds that you're leaving to them or the assets. And then charitable giving is another big one. So ultimately, your estate kind of goes into three buckets. You're going to pay the government taxes most of the time, either way. You're going to probably give some funds to charity. And the biggest one, as Rory mentioned, is giving the estate to your family and making sure that everyone who you care about receives what you'd like them to.
I would just say here, your assets are kind of in the middle. And I would also say that you're in control to a degree by creating an estate plan. Certainly the goal would be to reduce that top circle, the government or taxes, both from a control standpoint, but also from a tax standpoint. You don't want them receiving an excess amount of funds that could have been prevented with great proper planning. Now, creating an estate plan and creating a trust is not just this magic wand that allows you to escape taxes. A lot of that depends on what state you live in, who is inheriting your assets. We're going to get into a little bit more of that, but I think you want to have that control. These circles hopefully should not be in equal parts, and hopefully planning can help tilt the scales in favor of family. And if you're so inclined, you determine that charity component. Hopefully, we're trying to minimize the taxes of the government portion.
So your basic estate plan, I know most people have heard of, the biggest one that comes into play after your passing would be your last will and testament, or just your will, as most people would call it. Your will really details who you want your assets distributed to. It'll address the guardianship, distribution of unique assets, like if you have jewelry, cars, things like that, you can dictate in your will who will receive those. And it does help you avoid probate because it's basically you giving a directive of what you want done with your assets. During your life, some key parts of your estate plan that can come into play would be the general power of attorney. So that's someone can act on your behalf when you lose mental capacity. So, we see financial powers of attorney pretty often. So that's where if you're incapacitated, that's someone who can make financial decisions on your behalf, pay your bills, make sure that everything's still taken care of there. The durable healthcare power of attorney is similar to the financial, but this is where healthcare comes into play. So that's someone can speak on your behalf, make your medical decisions when you're unable to do so. And then your living will is the end of life instructions. So if you have no brain function and you want to kind of tell your loved ones, don't keep pushing unless, there is a solution in sight. And Rory, I'm not sure if you want to speak a little bit to trusts or any of those other points.
Yeah, I mean, especially during life, and general power of attorney is more so just an example and a story. Is early in my career, I received a phone call from a husband, and his wife had just unfortunately had a stroke and was in the hospital. And certainly that was more severe early on. She actually had the larger of the assets in a retirement account for herself, and was questioning the increased costs associated with medical, was almost bracing us and the team here for some withdrawals to pay for that. There was no power of attorney on file. Just because they were married did not give the husband the ability to take a withdrawal out of his wife's IRA. So that was kind of an example for me to start having those discussions with clients when clients get older. Now, older, in quotes, what's the magic age? There really isn't one. I think for sure it's as you start hitting your late 50s and 60s, start thinking about a power of attorney so that if God forbid something were to happen to you and you have a lot of retirement assets, that's an individual retirement account. No one can access that unless there's a power of attorney where you've granted another individual the ability to step in on your behalf, either springing, which is when it's needed due to medical reasons, or just
Mhm.
on an overall basis. So it's a good level of protection there that if you have a trusted loved one, commonly this is going to be a spouse, to think about having powers of attorney for each other as you begin to age. Now, fortunately, our client did have a great recovery, and the need for those withdrawals did really not occur until after she was able to make the decisions on her own. But that was one of the first steps we took, which was to push the client to work towards getting a power of attorney. Um, so hopefully that example is helpful.
Mhm.
It's like insurance. You don't need it until you really do need it. So it's something to think about and put in consideration. Um, I think we can kind of lead into trust on the next slide here, where after you pass away, the will dictates who the assets transition to. Trusts are going to give you a little bit more of control. I always associate the word trust to how someone or an entity can take action and control that. So more to come on that as we continue forward.
A common question that we also get in the office, and Rory, maybe you can speak more to this, is, who should I elect as my executor or my trustee? They're ultimately the person who, when you pass away, they make sure that everything is followed through. They execute your will, they execute what you've told them to do. So if you want to comment there.
Yeah, many times we see this to be a family member, but that family member could change. So my wife and I went through our estate plan and we made some edits a couple years ago. My oldest is now 11. When we initially created our estate plan, it was right before he was born. So we've made some edits to that, and one of them was changing the executor from one family member to another family member, just due to who was going to be best suited and who's in the best position at their stage in life to take on that responsibility, should that come to fruition. So choosing the executor, but then making sure that that individual is, ready, willing, and able. So
Mhm.
that willing should be communication. Maybe having that discussion before you name the executor is, sharing with that individual that that's your plan, and if they're willing to take on that responsibility. Certainly, there's going to be guidance from the attorneys in settling the estate, but the executor does have to be organized and make decisions and actually help carry forward the decisions that are put forth in the estate plan. So many times the executor and the qualities of an executor would also be relevant to the trustee, someone that would be administering a trust if that trust stays in existence beyond your lifetime.
And I think that leads really well into one of the, probably the most common question that we get from our clients who are all high net worth individuals is, do I need a trust? And they do think it's kind of that magic fix it button that if I put everything into a trust, I can avoid all the taxes. I get to say exactly what I want to happen to my assets, which is pretty true.
Mhm.
But I think it's a good distinction to make.
Yeah, what's the difference between a will and a trust? So there's a couple quick things that I always think about. A will determines who receives your assets. A trust determines who receives and how they receive the assets. So there's more control in that trust component with it. The other thing is privacy, to what Sam mentioned previously. The will is going to determine who receives those assets, but it's still going to pass through probate. So there is going to be some public information there, which could create some potential issues if the numbers are larger than anticipated amongst family members. Whereas
Mhm.
assets that are in a trust, and think of a trust as, kind of almost like a bucket, and then you're going to drop things into that bucket. A lot of it has to do with retitling. There's going to be some work. You can put properties in a trust. You can put investment assets in a trust. If we have a client that is managing an account, let's say they're a husband and wife, they have a joint account. When they move those assets into a trust, there's retitling that's done. So now
Mhm.
Ausperity is managing an account, and the name of the account is going to be the trust account. It's no longer going to be a joint account. It will be in the name of the trust.
Mhm.
The ability to make decisions is still going to be pretty much the same, but that is now how you put an asset in a trust. Many times it's just simply retitling. What happens is, in that instance, if the two individuals or the husband and wife pass away, they've made decisions in creating that trust for where those assets are going to go and how those assets might be utilized and spent. The assets might remain in trust for the benefit of children, so that children can take withdrawals from that trust or be granted withdrawals due to different stipulations. So if they're younger, like my children, I'm creating certain age limits to when my children can access the funds. And then I'm naming a trustee, which is a family member that would just oversee that that is done correctly and properly. Big benefit of the trust is it's going to avoid probate. So you're going to have bypassing probate, the privacy stays, the assets get transitioned over. So sometimes it's taking a look at, well, what is the purpose of this wealth and who's going to receive these assets if I were to pass away? There may not be a need for the trust if you're completely fine with knowing, okay, these assets go to my children and I trust them. It's their money. They can do whatever they want with it. The complexity and the cost associated with attorney fees and drafting the trust may not be needed or warranted. Instead, it's just directing the funds. So the estate plan might be a little bit more simple, and it's the power of attorneys, as we mentioned, and it's establishing the will so that the individual is determined. Whereas the trust is going to give more of that stipulation for, okay, it's going to go to my children, but I want to make sure that it's protected from creditors. So if they're ever part of a lawsuit or litigation, that trust is not going to be part of their assets. If there's ever a potential divorce, the assets are a non-marital asset because so long as they stay inside of that trust, they're protected from divorce filings. And then if you care about how your beneficiaries or how the beneficiaries of the trust get access to those funds, you make up the rules. That is also why you utilize a trust, so that the access and the stipulations for how that gets paid out is done there. So will is who, trust is who and how.
And I think it's important too, just to point out here that, you know, you will still have a last will and testament with your trust. It's not like your trust
Yeah,
becomes
great point.
the place of the will. I think that's a common misconception that you'll like get one or the other, and us having them next to each other probably furthers that belief. But yeah, your trust is actually like within your will in most cases, and then your will may be a pour over will that just makes sure everything that accumulates in your lifetime is either deposited to the trust or, you know, dictated where it should go. All right. And then this kind of just goes back to, you know, do I need a trust? We talk through this with most of our clients with minor children. We find that the most popular or common trust is the irrevocable trust because it allows you to maintain control while you're living. Rory's worked through this with estate attorneys, so I know you have a lot of knowledge here if you wanted to speak further to the revocable versus irrevocable and pros and
Yeah.
cons.
Yeah, I don't want to go so much in irrevocable. There's more complexity there. That is not as common. Many times the irrevocable trust is set up, and that is for tax reduction, but it's more federal tax reduction. And right now, those limits per recent legislation are very, very high. You will not have a federal taxable estate unless you have over $15 million as an individual. Or if you're a couple and you're married, you need to have a net worth at passing of over, or assets of over $30 million. If you're in that category, which some of our clients and several of them are either heading towards that or there, then irrevocable trusts are going to be more common. And in short, what you're doing there is you're setting up an irrevocable trust, and now you're giving up control. You're moving and retitling an asset into the trust. You no longer have control. The trustee is making the decisions administered through the terms of the trust, but the benefit is any future growth is now out of your estate. This could be properties, this could be business ownership, this could be investment assets. So irrevocable trust can be very beneficial. There's a lot of complexity here, especially if you tie in charities for ways of lowering your federal estate in an effort to reduce taxes. But the playing field has really been limited given that these numbers have increased dramatically. There was a time when the federal estate tax was at $1 million. This was a number of years ago. That's always a little bit of a moving target, but right now 15 million and 30 million, I think we're seeing a lot less of irrevocable trust. The revocable is, again, where you want to impart a little bit more of the control. As Sam mentioned in the deck here, it's good for shore homes. It's good for larger estates dictating how, who, when beneficiaries receive these assets, receive these funds. Shore homes are a tough one. Many times that's where the memories are. That's where the grandkids come back. That's where the children come back to. But with multiple children, many times the goal is, well, we want all of these amazing memories in this shore house to carry on beyond our death. It's tricky though. Who's paying the general upkeep, the property taxes? Is there a mortgage on the property? Pretty much every case, the children's financial situations and family dynamics are going to be different. So the shore homes are a tough one, and I think that's needed to be laid out in some sort of trust where the direction comes from perhaps mom and dad, and they've laid out the direction. If you have less of control, or there's no trust and it's just 50-50, figure it out. That we've seen some really tough situations and family strife when there's not considerable planning going on as it relates to inheriting a property that is, the plan is to keep it in the family, so to speak. So be careful of that one. There's really no magic bullet there other than take some time, make the decisions, and then communicate those decisions to your family. Don't let some of these difficult decisions be left up to just the beneficiaries with them trying to think, oh, this is what mom and dad wanted. That type of stuff is hard. So the revocable trust, there's no magic bullet. You're not going to get that. You're not using that to get assets out of your estate. That's not the tax reduction tool. That's more commonly going to be irrevocable trust. But in doing so, you're giving something up. You're giving up the control of managing that asset on a go-forward basis. So those are the two big things there. Focus on the revocable trust, which is really just you dictating the benefits and the terms of the trust and those assets.
I think this is a good visual to just kind of explain what Rory mentioned
Love
about
this. Yeah.
how to fund the revocable trust. I think, most of us are visual learners, so it's cool to see it laid out in this way. So to think through this, the grantor is the person who owns the assets during their lifetime. That's how I generally think about it. You transfer the assets into the revocable living trust. So that's where you still have control and you can receive the income or draw on the principal from that account or from that asset. If it were a shore home, for instance, if you put it into a revocable trust for the benefit of your kids, while you're alive, it's still fully your shore home. You can go visit it. You can, invite them, not invite them, fully up to you. And then when you pass away, the revocable trust would be the key piece in distributing that asset to your beneficiaries, whether that's family, friends, charities. So in the example of the shore home, the trust would kind of hold the asset, but then your kids would have usage of it or however you dictated.
I think this is a great visual. I'm super visual, so I think this is helpful. So let's say you have an investment account, you move it into a revocable trust, and then you have continued use and access to it. You're taking withdrawals from it, you can put money into it, etc. The account's been retitled. You pass away. You're probably either just going to name the beneficiaries that get the assets distributed directly to them, or you might have the trust separate the assets into two different trusts if you have two children, one for Bobby, one for Sally, something along that nature. And then you would have the terms laid out for how they could access that. So the revocable trust really is the hub. And then from there, you would have made the decision and laid out the terms for that. We're going to get to it. Well, man, there's all these options. How do I make these decisions? We'll get to that later, but this hopefully is the visual that kind of ties this together. You have the asset, you retitle, move the assets into trust. From there, you have full and total use of it, but you are determining who and how and even when assets are distributed when you're utilizing the trust.
Perfect. And then this is just a little bit more of a breakdown. So Rory, if you want to speak to this.
Yeah, this is a little busy. We're not going to go through this, but it's showing a little bit more of a timeline or a flow chart, if you will, of the assets. And this can be done if something were to happen. So in this case, we have David here. David and Victoria. David passes away. Where do those assets go? Where do they flow? From a visual perspective, this is extremely helpful. I have found that clients establish and create an estate plan, and then after a couple of years, they kind of forget, well, what happens and where does it flow? So what we're trying to do more of as a firm is be a little bit better at creating these visuals for clients, pushing on the estate planning attorneys that perhaps help us in creating these visuals and these flow charts. So it's a little bit more, so it's a little bit easier to kind of follow and understand and make updates to. Leave this broad, but this is an example of kind of seeing a level of detail. Imagine how powerful this would be in having a discussion with children. You could take the dollars out, but you at least could share the flow of assets so that they know, or the discussion and bringing this to the trustee who is going to take the responsibility of administering the trust. There are some questions in the chat. So what type of trust is best to utilize, and what are the differences in the various types of trust? That's a great question, but that is a great specific question to have with an estate planning attorney, or to kind of receive guidance in terms of working through that. So the best trust for you, I would gather, unless you're looking at getting assets out of your estate and losing control, is going to be a revocable trust. Dictating the terms of that would be up to you, and is best done as you go through the estate planning process. Where another question kind of feeds in similar to that is, does Ausperity provide the guidance for a will versus a trust, how the trust is set up, or is that done with lawyers, or do both groups weigh in? Phenomenal question. I think my answer is both are going to weigh in. The discussion is usually with our team. Here at Ausperity, we know enough to be dangerous. We kind of help quarterback it. So I think that we can really paint the picture for you, but the drafting is going to be done either with an estate attorney or through a self-directed platform like wealth.com, which I know is a really good lead in, and Sam is going to kind of take there. But this flow chart was actually created by wealth.com. So we're going to go through the two different ways you can generally go about creating an estate plan. So I think Ausperity and the advisors here are going to be really helpful in what in high likelihood is going to be utilized and why, whether a will is good enough or whether taking the necessary steps of drafting a trust would be beneficial. But then that's going to be solidified when you go through the estate planning process. So thank you for the questions. Sam, why don't you hit into wealth.com?
Yeah, awesome. Let me just jump there. So how can I create my estate plan? As Rory just mentioned, you can create it with an estate attorney, which for more complex plans, would highly recommend, because you'll want to make sure that you have all of your questions answered and that you are solid on your plan. Another option that we've recently started offering is access to a virtual estate planning platform known as wealth.com. So wealth.com is kind of gamified for estate planning, in that you would get a login from our team. We'd import the data from your financial plan, so all of your assets should be listed there, as well as your closest family members. We can always add other ones, but on a baseline, it's usually you, your spouse, and your children, if there are any. So that way you can create your wills, healthcare directives, and powers of attorney. So I'll just jump into a few slides that give you the visuals of wealth.com. So this is where you kind of get started in wealth.com. You'll notice that there is the individual revocable trust, which could also be your last will and testament. They do go hand in hand. And, if I created my revocable trust, I would also have that pour over will, as I mentioned earlier. Then it brings you to step 2, which would be creating your advanced healthcare directive. So appointing someone to make healthcare decisions for you if you're incapacitated, and to make end of life decisions. So that's where you can kind of really get into the weeds of what you'd like to do at the end of life. Then you'd also appoint your financial power of attorney. I think it's important to note here too that wealth.com is applicable for all states. They are not a law firm, but they can generate the documents and have a lot of great tools to explain the details of each decision that you make. So this is kind of how you would work through it. You would start your will, confirm all of your details, and it would ask you a few questions as you go through so that you can make little adjustments, and it's really customizable. Then, as I was mentioning, there is this frequently asked questions section throughout wealth.com. So every option that you select, the frequently asked questions box will be there, and it will explain to you like the common questions, or if you find that you run into a question that is not frequently asked, there is the consult an attorney feature on every profile so that you can go in. I believe there is a fee per half hour for consulting the attorney, but it's definitely much less expensive than if you were to work with an estate attorney. So I think wealth.com is really the easy button for creating a baseline estate if you don't have one already, or if you don't feel that you'll need a trust. Say you have adult children, you don't have a ton of properties, if it's pretty straightforward.
Yeah, Sam, just to jump in, I think your word baseline is excellent there. I think with more complexity, an actual estate planning attorney can help you talk through what you're trying to accomplish, your situation, can give you perspective on other individuals and families similar to you and how they help solve some of those issues or grant those estates. Going through the process on wealth.com is a bit of a heavy lift. With that said, it is a way for you to control it on your own timeline. It's likely to be less expensive than utilizing an estate planning attorney and kind of going through that process and having it drafted, but it is a really solid baseline. There's, the heavy lift in the sense that you have the resources there to take advantage of, to work your way through it, to ask commonly asked questions. There's the chat feature with it. And then you also do have the attorney. Now, they've retained attorneys all over the country that you can utilize and get access to. That again, they're licensed estate planning attorneys that, in addition to their practice and law firm, they've been retained by wealth.com to help and assist with the process. So it's an amazing feature, but it's specific to you, your comfort level, the complexity, and your family in terms of whether you want to go the route of wealth.com or the estate planning attorney. I think the added complexity of your situation or your needs likely might dictate more of an estate planning attorney than going through wealth.com, but the capabilities are there for wealth.com. Sam, we're getting a couple questions here.
Yeah.
So just trying to help go through and navigate this. So one of them is irrevocable trust. Can you not name yourself the trustee to maintain execution of the funds? The answer, usually no. I mean, irrevocable trust is you're giving up control. I would say with that, there is a little bit of an indirect guidance there because there is a trustee and you're determining who the appointed trustee is and how they're supposed to act based on the terms of the trust. So you're kind of setting the framework for how it should be guided, but usually speaking, you're not naming yourself as the trustee on an irrevocable trust. There could be that conflict of interest. You could argue that you haven't given up control, which could make the irrevocable trust null and void and really bypass the entire need for why you established the irrevocable trust to begin with. It more so would revert back to revocable trust status, in which case then you're not getting any appreciation or future appreciation out of your estate there. A quick one. If you have assets in multiple states, do you need multiple trusts? Great question. Probably not. If you have a solid established estate plan, depending upon how you term the drafting of the particular trust, multiple states do not necessitate multiple trusts.
The assets may be taxed differently in each state when you
Good
pass
question. Yeah.
away, but like Rory said, you can probably have one document that dictates everything. Your executor or the trustee would just need to ensure that each state, kind of gets their piece of the pie when it's being distributed.
Yeah. If you have an existing will that needs to be dusted off, I love using our terminology. Is it best to revisit the original attorney, assuming that they're still around, or should you start over with wealth.com? Another great question. I would go back to the existing attorney. You've already paid a pretty decent amount to get all of this established. Going back for an edit, it would be my recommendation. there's a chance that that could be free. It could be part of the original package that you paid for. If it's just a review, you might just be paying an hourly rate for a review. And because that attorney has the trust on file, they drafted the original one, they're probably best to be the first reviewer. I would go there first. And if they're not around, but the practice or the business is, and it's a larger law firm, I still would go that route and have another attorney on the estate planning side review that first. I think you're going to get amazing feedback, and then they can make those necessary edits, or if need be, scrap it and go the entire route. But if you've already gone down the road and you've paid an estate planning attorney for the original will, I would revisit that first.
Yeah, I agree with
Great.
that. And I think just one thing to interject, Rory, is that one key piece here that we didn't mention, like how can I create my estate plan? And it's just came to me, is that if you pay for legal insurance through your workplace, you can also check if they are able to create your wills, powers of attorney, and just draft your documents for you. I actually had a client recently who worked for Merck, I believe many years ago. They reached out to their legal team because they were told, that they could create their wills through them. And Merck had paid for all of their employees to have access to the service, even through retirement, so they could update their wills, trusts, powers of attorney through them. There's just another good resource to turn to and make sure you're not paying for something that you're not using.
Yeah. No, it's an amazing point. And again, this is not, estate attorney or software. Doesn't have to be wealth.com. There's LegalZoom, there's Trust and Will. Just Ausperity has done our due diligence. And what's most impressive to us is wealth.com. We had one of the advisors go through the entire process themselves to vet it as well. This was also recommended to us from other independent advisory firms with great success. So we're bringing wealth.com to the client base because we've been impressed with it. We've kicked the tires on it. But there are other ways of going about doing this, and there's other software. I think the big takeaway here is review what you have. Solidify that that's appropriate for today. And then also, if you don't have anything, utilize something. Get started. It's so much easier to edit something that's already been done than to start it from scratch and then to kind of go through. I think too many of our clients I hear, they don't have all of the answers. And you may not have all of the answers, but I'd push you to make the decisions based on if, God forbid, something happened today. I think too many families are trying to have the perfect solution. And because they don't have the perfect answer or the perfect solution, they do nothing. And I think that's a massive risk to the family.
Yeah, I agree with that. It's, one of the biggest holes in a lot of financial plans, not just at Ausperity, but across the country and the globe, or that they're missing an estate plan. And you don't want to leave, your loved ones unprotected. And probate can also be a really long process. So, if your kids would need the help immediately, you don't want them to have to go through a drawn out legal process just to get access to pay your burial expenses or be able to make those final wishes come true.
Exactly right. And also that's state specific. Florida, for example, is a well-known state that's difficult and expensive from a probate perspective. So many individuals that are Florida residents, they're more privy to utilizing a revocable trust more so than someone in another state. There's other things. Sam, why don't you take this one? So beyond the probate process, we talked about federal estate taxes. Individual 15 million, couple $30 million. That's not it. There's also the state that you live in could have estate or inheritance taxes.
Yeah, so I'm happy to kind of address this slide here. I think we did New Jersey and Pennsylvania because that's where a majority of our clients reside, but we can always look into the inheritance tax rates wherever you're living, and we're happy to do so and consult. We like to be connected with everyone's estate attorneys and accountants, as I'm sure you've noticed. So you can always put us in touch so we can work through the details here. But on a baseline, spouses in New Jersey and Pennsylvania, I like to think of that as kind of a lateral move. So if you have an individual retirement account and you pass away, that kind of just moves right over to your spouse. Those accounts are combined as if they were just always one. And then for your children, I know New Jersey used to have an inheritance tax for children or direct descendants, but they took that away a while back. So now it's 0%. Pennsylvania, unfortunately, does have an inheritance tax, which is 4.5% for your kids. So if they inherit your like non-retirement assets or accounts, there will be an inheritance tax there. And then for siblings in New Jersey, theirs is a little bit funky. So the first 25,000 is exempt, and then the rate spans from 11 to 16%, depending on the amount that they're set to inherit. For Pennsylvania, it's just a flat 12%. So if I were to give my sister, all of my estate when I pass away, it would be a 12% tax. If I were to give it to my children, it would be 4.5%. And
Yes.
then for sorry, go ahead, Rory. I'll
No,
pause
I'm just
there.
going to jump in just to clarify something because of questions we've seen before. So the
Yeah.
children are not the ones that are paying that tax. What happens is the estate is settled and then the net assets are passed down. So that's a clarification item.
Yeah, no, that was a good point. The estate pays the tax, not the kid themselves. And then for other heirs like nieces, nephews, aunts, friends, in New Jersey, it's 15% on amounts up to $700,000, and then anything above 700,000 would be taxed at 16%. Pennsylvania, that is just a flat 15% tax rate.
Got a couple questions as we're going through the state. So are the documents state specific? If these documents were created while you were living in one state, do you need new documents to be created if you move to another state? So it's a really good question. Short answer is not new documents, you're not scrapping it, but an edit probably is needed. So that is one of the reasons if you do move or you acquire property in a different state or you move, especially if you're going to have a new state as your primary residence, you would want to go through and have an edit or an update made, but brand new documents may not be needed.
Yeah, and I think, sorry,
But
Rory, not to cut you off, but with wealth.com, one of the key features that really swayed me that they were the right solution for Ausperity was if you are to move states after you've drafted your documents with wealth.com, all you have to do is go in, update your address, and then it will automatically update your documents to follow that state's laws. So I just think that's a really cool feature that it has.
that's great. Another question is inheritance tax in Florida. So short answer, 0. There's no inheritance tax. There's no estate tax in Florida. Some of the states like Pennsylvania or even New Jersey potentially on where the assets are going, estate planners we've heard advise, well, I have a secondary home in Florida. It's how much do you like that home in Florida? Could you spend 6 months and a day in that home in Florida and actually change residency to Florida where there is 0 inheritance tax, there is 0 estate tax beyond your Pennsylvania residency or possibly New Jersey residency or Connecticut residency where there are estate or inheritance taxes there. So in Florida, there isn't anything, which is why it's a very popular state for retirees and high net worth individuals to claim residency. But I will say it is real. New Jersey or Pennsylvania is going to want to claim you if you pass away. So the 6 months and a day is a real thing. And that's a whole different discussion. But short answer, there is no inheritance or estate tax in Florida. I think that's it for the questions so far here, Sam.
Awesome. I think I can just jump back maybe to one slide that we did kind of skip by, was just when should I create my estate plan? And, we mentioned that it's as soon as possible. And then when should I update it? Rory just made a great point about, if you move to a new state, that's when you would want to go in for an update, not necessarily all new documents. When you welcome new family members, if you have a large inheritance that comes through, when you're married, when you're divorced, and if you're selling a business, if you run into health issues, or when your minor children become adults that you believe are capable of handling what you're going to pass down to them.
Yeah.
And then there's also a timing element, which is every 5 to 10 years, it is good to just dust them off, see what's going on. And if anything's changed since you last took a look, or if the laws change. So federal or state, the federal gift tax limits used to be very low. and now they're at 15 million per person. So we have a lot of wiggle room for most people, but if that drops back down, that's when you might consider updating your documents again.
Yes, awesome job with this slide. This is a keeper, and we get a lot of questions regarding this. Speaking of questions, another one just popped in. I live in Pennsylvania now. How many years would I have to live in New Jersey? Parentheses, we own shore property. Okay, so we live in New Jersey where we own a shore property in order for my daughter to avoid any state inheritance tax when my wife and I pass. I'd probably double check my answer to be fair, but so there's no yearly requirement. There's no number of years. Rather, it's the state that is your residency or the state you domicile when you pass away. So if you pass away as a resident of New Jersey, your daughter probably will not be taxed on a New Jersey asset. Would be my case because it's your asset, it's part of your estate, and if you're passing away as a New Jersey resident, if that's where you reside and that's where you're filing. But if you live in Pennsylvania now and you pass away, you're going to be going through the Pennsylvania probate process, the Pennsylvania inheritance process. So that would be, okay, how do you make New Jersey your primary residence? And are you spending 6 months and a day in New Jersey to claim New Jersey status there? Hopefully that answers that question. I think it's a little bit more nuanced. That would be something a little bit more specific for an attorney.
Yeah, I don't think there's like a look back period for it because that wouldn't be fair, but yeah, definitely worth delving into with an attorney. Perfect. Were there any other questions in the chat, Rory, or anything else we should hit on that you don't think we did?
Not that I'm seeing. Again, hopefully this is motivating. Hopefully there's some takeaways. You've learned something. You've reconfirmed a little bit more of that constant question of the difference between a will and a trust. So it's our kickoff webinar for the year for a reason. Everyone works very hard to create wealth in this country and to maintain that. Our hope is that you take the necessary steps to protect yourself and protect your family and your loved ones. So this entire deck will be sent to every attendee in a follow-up email. Feel free to share it with friends and family. Yeah, with that, I wish everyone a wonderful 2026. Any one-off questions, send to Sam and myself directly. Sam, awesome job with the presentation and putting it together. It was fun going through this, and I hope it was a great use of everybody's time on a Wednesday in January.
Yeah, awesome. Great job, Rory. Thank you guys for coming and have a great day.